coronavirus, and we will, but we also have other things to do necessary for the good of the nation, like filling judicial vacancies. We're getting comments throughout the country about the vacancies, how they're impacting the ability to deliver justice in various states, and we'll be as prompt to that as we possibly can. My Democratic colleagues are requesting hearings on the effect of the virus in prisons, state and federal, and detention centers for immigration purposes, and we will try to work together to have those hearings. I'm curious myself about the state of the play in our nation's prisons and our immigration detention centers, so we'll work on that as quickly as we can. Hopefully next week we'll have a hearing about liability issues related to the virus. What can we do as a Congress to safely open up the country and minimize legal exposure for those who are trying to reopen the American economy? That's a very important topic for me and many of us here. Today we're going to deal with the vacancy at the D.C. Circuit Court. Justice Mr. Walker, Judge Walker from Kentucky, has been nominated by the President to fill this vacancy. I think he's a highly qualified individual, and Senator McConnell will be submitting a written statement. To my colleagues, if it's okay, could we hear from Senator Paul, then each of you can make statements? Is that okay? Is it okay? Senator Paul, the floor is yours.
Thank you, Mr. Chairman, for allowing me to introduce Judge Walker. I'm very pleased that President Trump reached outside the Beltway to New York bubble to elevate a judge who is committed to our Constitution and to be elevated now to the nation's second most important court. Judge Walker will be the first judge confirmed to the D.C. Circuit from outside the bubble since Thomas Griffith, the judge he is replacing, was confirmed 15 years ago. I was honored to recommend Judge Walker for the District Court, and I was honored to recommend Judge Walker now to the elevation to the D.C. Circuit Court. I was unable to be here for Judge Walker's hearing last year because I had to have urgent lung surgery. If I had been here, I would have told you how I met Judge Walker through my friend Mike Lee and how I was immediately impressed by his legal knowledge and critical thinking about the law. In Judge Walker's short time as a district judge, he has shown an unwavering fidelity to the Constitution. In early April, our nation was in the middle of a health crisis. Politicians around the country began clamoring and claiming tremendous power over parts of our everyday life. While many in the public cheered them on, governors and mayors were seemingly in a race to see who could restrict their citizens' movements the most. Eventually, governments began to enact restrictions that prevented even the free exercise of religion. On the Friday before Easter, our governor ordered the state police to record the license plates of churchgoers on Easter so they could be forcibly quarantined. The mayor of our largest city banned churches from holding Easter services, including a drive-through service where the worshipers would stay in their car. With the weekend looming, one church went to court and Judge Walker was assigned the case. The easy thing to do would have been to wait until the following week to hear the case, with Easter having already passed. Instead, Judge Walker saw such a clear violation of the First Amendment that he issued a rare Saturday order blocking the city from criminalizing Easter. I'm sure each of you have read this opinion in preparation for this hearing. If not, I commend it to you as it demonstrates the depth of his knowledge of the law and history. More importantly, it demonstrates his fidelity to our Constitution, even when it is hard and even in times of crisis. Judge Walker is just the kind of person we need on the bench. I proudly support him and urge you to swiftly send his nomination to the floor.
Thank you very much, Senator Paul. Senator Feinstein, would you?
Thank you very much. I will, Mr. Chairman. Thank you. I would like to begin by thanking all of the frontline workers who have spent untold hours responding to the COVID-19 pandemic, from doctors, nurses, first responders to grocery store workers, bus drivers, farm workers. These men and women have helped keep us safe and well. I know I speak for all of us when I simply say thank you. Today, the committee is moving forward with a hearing to consider the nomination of Justin Walker to the D.C. Circuit. The Senate confirmed Judge Walker to the District Court for the Western District of Kentucky on October 2019 with no Democratic votes. After serving just 6 months as a district court judge, He has now been nominated to the D.C. Circuit. After the Supreme Court, this is the most important court in the country. Its rulings have national implications, including on issues such as health care, the powers of the executive branch, workplace, and environmental safeguards. In his short time on the bench, Judge Walker, just 37 years old, has had virtually none of the experience one would expect of a district court judge before elevation to the circuit. He has not presided over any bench or jury trials. He has written opinions in only 12 total cases. It's not surprising, then, that groups like the Leadership Conference on Civil and Human Rights have opposed Judge Walker's nomination, partly because of his, quote, lack of experience, end quote, which, quote, paints a vivid picture of an individual who is unworthy of a lifetime appointment to the federal judiciary, end quote. More than 200 groups, including the Leadership Conference, NAACP, and National Council of Jewish Women, also oppose Judge Walker because of his record against expanding access to health care and against safeguards for the environment, consumers, and the workplace. In its letter, Protect Our Care noted Judge Walker's statement that the Supreme Court's decision to uphold the Affordable Care Act was, quote, indefensible. That letter, signed by 53 groups, excuse me, expressed concern that Judge Walker's confirmation could, quote, exacerbate the health care crisis in this country. I will ask Judge Walker today about this record and whether he can fulfill the judicial standard of fairness and objectivity that we should expect from our federal bench. Thanks, Mr. Chairman.
Thank you. Would you, Senator Durbin?
Thank you very much, Mr. Chairman, for giving me the opportunity to make an opening statement. When we heard that Senator McConnell was summoning us back to Washington, D.C. after 5 or 6 weeks where we were, most of us, sheltered in place at home, I was waiting to hear the agenda. I knew what America was focused on, a national emergency, in the words of President Trump, a public health care crisis that we hear about every minute of every day that has literally changed the lives of so many people across America, and as of this moment claimed at least 70,000 American lives. 1.2 million people infected, at least based on testing so far. It is the gravest challenge and crisis that we have faced, many of us, in our lifetime. And so I thought if the Senate Judiciary Committee is coming back for business, there's certainly a lot of things we can bring up related to this COVID-19 crisis. We could certainly be asking the Subcommittee on Border Security and Immigration to address the issue of over 50,000 DACA and TPS classified critical health workers in America whose status under the immigration laws of our country are at least uncertain. We could be bringing that up and discussing whether or not we can afford to lose 50,000 healthcare professionals at this moment in our history. The Subcommittee on the Constitution could have asked us to take a look at how the election is going to be held in November, whether Americans are going to have an opportunity to vote, even if they're fearful of leaving their homes and going to a polling place. The Subcommittee on Crime and Terrorism could have certainly asked us whether we have sufficient protective equipment for police and first responders, and whether we're doing all we can to protect federal prison guards. Take a look at the numbers, if you haven't seen them, in the Bureau of Prisons, not just of the incarcerated who are infected, but also the guards who are being infected as well. We could have, of course, asked the Subcommittee on Oversight to take a look at Senator McConnell's own suggestion that we address the issues of liability across the board in terms of COVID-19. Certainly a worthy topic and one that we may, I understand, bring up next week. AARP tells us seniors across America are facing health care scams at a record number because of this COVID-19 crisis. This is within the jurisdiction of the Senate Judiciary Committee. The list is lengthy, and unfortunately, it isn't the reason we're returning this week. Instead, we're considering the nomination of a 37-year-old family friend of Senator McConnell's to the second highest court in the land, a nominee who has a record, ironically, of stridently opposing the Affordable Care Act, which seeks to extend health insurance coverage to more Americans, and who was last year found unqualified to serve as a district court judge in the Commonwealth of Kentucky. But now, after his 6-month career on the Kentucky District Court, he's obviously, in the eyes of Senator McConnell, worthy of a promotion to the second highest court in the land. This is the second time that Senator McConnell has prioritized this judge over the coronavirus. The first was when he recessed the Senate in March to attend the ceremonial investiture. Senator McConnell said last week that when it comes to COVID-19 pandemic, quote, "We cannot get distracted by pre-existing partisan wish list," end of quote. That is exactly what is happening in this hearing. We're in the middle of one of the greatest public health crises in the history of our nation. We're sitting in a committee with jurisdiction in so many critical areas when it comes to this crisis, and instead, Senator McConnell is unwilling to set aside his wish list to filling the courts. The American people deserve better.
Thank you. Judge Walker, would you please rise? Yeah, please.
Can't hear him.
Yeah, there we go. Raise your right hand. Do solemnly swear the testimony you're about to give this committee is the truth, the whole truth, and nothing but the truth, so help you God. Thank you. Yes, if you could just pull the microphone close, the floor is yours. You need to turn it on. There we go.
Thanks, Chairman. Good morning. I'd like to thank my home state senators, Senator McConnell and Senator Paul, for all the support that they've always shown me, and thank you to Senator Paul for the statement that you made today. Thank you to Chairman Graham and Ranking Member Feinstein for holding this hearing, and to Chairman Graham for chairing it. Thank you to the President for nominating me. To my wonderful wife, Anne, and my precious daughter, Isabella, thank you for all your love. To my mom, Debbie Walker, thank you for being the great role model of my life. Thank you to all the family and friends and supporters who have been there for me before and during this process. And thank you to my clerks and colleagues on the Western District of Kentucky for your wisdom and your advice. Thank you, Chairman Graham.
Thank you. We will go by seniority. I think that's the easiest way to do it. Anybody wants to do it by video conference, ask questions, we have that capability. I want to introduce into the record the ABA rating regarding Judge Walker, and I'll do that now. He was determined to be well qualified by a majority of the committee. A minority determined that he is qualified, and a minority determined that he is not qualified. So I'd like to introduce that into the record, if I could right now. Tell us a bit about the case involving, in Kentucky, involving the church that Senator Paul mentioned. Could you walk us through that very quickly and give us your reasoning as to why you ruled the way you did?
Certainly, Senator. On the week before Easter, the mayor of Louisville announced with 5 different statements that it was not allowed for members of a church to worship at a drive-in church service on Easter. The plaintiffs in that case reached out to the mayor on Thursday and asked if they could nevertheless have their service in spite of what he had announced. and the mayor did not respond to the plaintiffs. On Friday, they filed a motion for a temporary restraining order that arrived on my desk at about 6 p.m. Friday. I had to make a decision, and I had to make a decision quickly so that people could know on Saturday whether they could go to church on Easter Sunday. In looking at the law, it seemed to me that the free exercise clause of the First Amendment prohibited the action that the mayor was taking. It was a long opinion, and it was a long opinion because I believed it was a momentous and even severe thing for a court to enjoin a mayor in the midst of this terrible pandemic when the mayor is asserting that his actions could save lives. And I only made the decision I did because that is what the law required. And I explained it in depth because I did not believe that it would be possible to explain the meaning of the free exercise clause without explaining the history of the free exercise clause.
Thank you. You mentioned, I think it may be Investiture somewhere, about the holding in the Obamacare Justice Roberts' decision to determine that this was a tax, and Congress had broad authority to levy a tax. Can you tell us what you were talking about, and why did you say what you did, and why pick this opinion out for comment?
Certainly, Senator. The case I was referring to is NFIB v. Sebelius. That decision is binding law on all lower court judges, and as a sitting district judge, I follow NFIB fully and faithfully. The year I was clerking for Justice Kennedy, that case was the most public, high-profile case of the year. And as you can imagine, Chairman Graham, no Supreme Court justice likes being in the dissent. And in Justice Kennedy's circumstances, it's of course not a position that he found himself in often. At my investiture speech, I wanted to pay tribute to Justice Kennedy. I wanted to tell him that he changed my life by hiring me. And at the end of a paragraph paying tribute to Justice Kennedy, I made a lighthearted allusion to his dissent in NFIB v. Sebelius. It was nothing more than a tongue-in-cheek way of recognizing what's certainly in the public record already, what's in the United States reports, and that is that the Chief Justice wrote a majority opinion holding that the individual mandate was a tax and that Justice Kennedy dissented.
Thank you. Senator Feinstein.
Thanks, Mr. Chairman. In a 2018 op-ed, you called the Supreme Court opinion unfolding the ACA a, quote, indefensible decision, end quote. You likewise praised then-Judge Kavanaugh for providing what you called a roadmap for the Supreme Court to strike down the ACA. How was the Supreme Court's opinion upholding the ACA indefensible?
Senator, a few things. The first is that, as I said to Senator Graham, the court's opinion in NFIB v. Sebelius is binding on me, and I would follow it fully and faithfully. The second thing is that when I wrote that op-ed, I was not a district court judge. I was an academic and a citizen engaged in matters of public concern, as many judges were before they became judges. And I understand that my role now is different than my role then. With regard to what I specifically wrote, I did, as an academic, criticize the legal reasoning in the majority opinion in NFIB v. Sebelius, but that was not a commentary on the merits of any particular healthcare policy. Rather, it was a legal analysis about the constitutionality.
Well, that's not the only time. In March of 2020, at your investiture ceremony for the Western District of Kentucky, you publicly discussed the court's ACA opinion. There you said that the, quote, worst words, end quote, you heard while clerking for Justice Kennedy were, quote, The Chief Justice thinks this might be a tax, end quote. That was an apparent reference to Chief Justice Roberts' opinion upholding the ACA as a function of Congress's taxation power. If you were willing to discuss the court's opinion at your investiture while you were sitting lower court judge, why are you unwilling to do so now?
Senator, as I tried to explain to Senator Graham, that statement, that lighthearted allusion to something Justice Kennedy wrote when I was a clerk, was part of a paragraph talking about the very important relationship that I have with Justice Kennedy and how he has been an invaluable mentor and friend to me since I clerked for him in 2011 and 2012. It was not meant as anything more than a reference to the dissent that he wrote, and again, a bit of a tongue-in-cheek allusion to the reality that no Supreme Court justice likes being in the dissent.
The COVID-19 pandemic has already had an outsized impact on those who lack coverage or access to health care. But if the ACA were to be struck down, as you have advocated, even more Americans would face devastating health and financial consequences. Why, in the middle of a pandemic, should we support a nominee who would take away health care from millions of Americans, including those with pre-existing conditions?
Senator, the COVID-19 pandemic has put this country in an unimaginable crisis. I doubt there's anyone in this room who either hasn't been affected or doesn't know someone who's been affected, either in terms of health or in terms of the economic impact. And I know I certainly have friends in that category.
That's your answer?
No, I'm sorry, Senator. I was going to add that it's not the role of a judge to opine on healthcare policy. A judge, a district judge, as I have been for the past 6 months, and as a DC Circuit judge, if I'm lucky enough to be confirmed, has a responsibility and a duty to go where the law leads, to go where the Constitution leads. That's what I've done as a district court judge, and I've done it without any policy preferences or any consideration of whether or not I like the policy outcomes, whether the policy has to do with healthcare or something else. You're not a good judge if you always like the policy outcomes that result when you go where the law leads and take each case by case, with an open mind.
One quick last question. At your investiture speech in March, you praised Justice Brett Kavanaugh, who was in attendance, and said, and I quote, "In Brett Kavanaugh's America, we will not surrender while you wage war on our work or our cause or our hope or our dream." What did you mean by Brett Kavanaugh's America?
Well, Senator, Justice Kavanaugh and Justice Kennedy are mentors of mine, and I will defend both of them. I'll defend them both until...
No, I'm not attacking them. I'm just asking you what you meant.
And what I meant is that I think Justice Kavanaugh, as well as Justice Kennedy, are outstanding judges. And I think that good judging means being faithful to the original meaning of text and consideration of structure, precedents, canons of construction, etc. And so I was in my speech saying that I am unabashed, as other judges have been, in my defense of the rule of law and of the approach to judging that considers text rather than inserting a judge's political opinions into what the law is.
All right, because as I read it, you referred to our work, our cause, our hope, and our dream as being different from what is usually taken, but identified it with Justice Kavanaugh's views. And I'm just interested in knowing what that meant.
Certainly, Senator. I think Justice Kavanaugh's approach to the law respects separation of powers, it respects the judge's limited role in our Constitution structure, and it demonstrates fidelity to text. And those were the kinds of legal principles that I was praising when I was praising Justice Kavanaugh in my investiture speech.
Thank you. Appreciate that. Thanks.
Senator Grassley.
Judge Walker, I'm going to ask you about Chevron because most other circuit judges, to my don't do as much with administrative rulings as the court you're appointed to. So please understand, give me your understanding of the Supreme Court holding in Chevron. When, if ever, is it appropriate for a judicial branch to defer to the executive branch's interpretation of law?
Well, Chevron is an opinion from the 1980s from the U.S. Supreme Court that has two steps. At the first step of Chevron, once that step is triggered by a formal agency rulemaking, the judge considers whether or not the statute that authorizes the agency's regulation is either clear or ambiguous. And at that step, the judge looks at the text, considers structure, history, canons of construction, and precedents, and decides, is the statute clear or is the statute ambiguous? If the statute's clear, and if it clearly authorizes the regulation, then the regulation is valid. If the statute's clear and it clearly does not authorize the regulation, then the statute is invalid. However, if the statute is ambiguous, then the judge moves to Chevron Step 2. And at Chevron Step 2, the judge considers whether the agency's interpretation of the statute is a reasonable interpretation. If it is a reasonable interpretation, then the judge upholds the regulation. If it's not a reasonable interpretation, then the judge holds that the regulation is invalid.
Has Chevron given too much authority to administrative agencies?
Senator, it's not for me as a sitting judge to critique binding precedents of the Supreme Court like Chevron. Chevron is still absolutely good law, and I'm bound by it now as a sitting judge, and I would be bound by it on the DC Circuit. As an academic, before I became a judge, I wrote about Chevron deference. I made some predictions about where the Supreme Court might go in the future based on some of the things the Supreme Court had done in the recent past. And I can give you one example. In the decision King v. Burwell, the Supreme Court recently held that Chevron does not apply to certain agency regulations when they involve a very major question. And so my article discussed that.
Okay. The next question I ask almost every nominee for the judiciary branch. I want to know how you would consider foreign law in your deliberation of a case. In your opinion, is it ever appropriate for a judge to rely on foreign law or this other quote-unquote views of the world community that I've sometimes heard people refer to in determining the meaning of the United States Constitution or statutes?
Senator, as a district judge, I have never relied on foreign law. I think as a general rule, it's very rare that a judge should rely on foreign law or consider foreign law. There are exceptions to that. If a contract, for example, between the plaintiff and the defendant has a choice of law provision that refers to the law of a different country, then that might be part of the contract that the judge interprets. A judge also might consider ancient English law when determining the common law that informed certain constitutional provisions that the framing generation wrote and ratified.
Here's something that has come up very recently, and in my opinion, too often, in recent decisions, particularly in the 3.5 years of this administration. Is it ever appropriate for a federal judge to issue a nationwide injunction blocking the implementation of federal laws agency decisions, executive orders, or similar federal policy? And if you think it is okay, when and why?
The question of nationwide injunctions is a question that is currently being litigated in courts across the country and could certainly come to me in a future case in my role as a district judge on the Western District of Kentucky or on the DC Circuit if I'm lucky enough to be confirmed there. So what I can say, Senator, is that if you look at the injunctions that I've issued as a district judge, including in the opinion that Senator Paul referred to and that I was asked about earlier by Senator Graham, it's a narrow injunction. It notes specifically that I was issuing an injunction that bound the defendant with regard to the particular plaintiff in the case.
Thank you, Judge Walker.
Next, Senator Leahy will be joining us by video conference. Senator Leahy.
Thank you, Mr. Chairman. It is interesting having this hearing, and I'm going to submit a statement for the record.
Without objection.
And in my statement, I should note that here we are in the midst of a pandemic that's taken around 70,000 American lives. Will take a lot more. We're holding our first hearing on a judicial nominee for a vacancy that isn't even vacant until September. But I'll submit my questions, and I hope that we might go back to going to hearings that really affect what's hurting Americans today. Now, Judge Walker, you haven't hidden your contempt for the Supreme Court's decision upholding the Affordable Care Act. I've heard what you said to the other senators, but you called it indefensible and catastrophic. And once you were a sitting judge, you referred to Chief Justice Roberts' rationale for upholding the ACA, that it may be attacked as the worst words you could hear. It is interesting to hear a sitting judge castigate a Supreme Court Chief Justice that way. But did come after your White House interview for this position that you're here now and before your nomination. Many felt that it was practically an audition for this, and it's no secret how you would rule on the ACA. I might ask you this question. Do you know how many millions of Americans have become unemployed because of the COVID-19 pandemic?
Senator, I know that there are millions of unemployment claims being filed. There are many people who are hurting right now, and I know people who have become unemployed and who are hurting right now. My heart goes out to all of them.
Yeah, that comes across very, I'll leave that alone. I'll let people decide how sincere you sound on it, but there are 30 million Americans lost their jobs in the last 6 weeks. Now, over 50 million have pre-existing conditions. Throughout the ACA, those with pre-existing conditions are never going to be able to get insurance. Those 30 million are going to be without insurance, but I'm glad you feel badly for them. Now, let's go to the Fisher case. I found it remarkable for a number of reasons. It goes to various historical examples where religious liberties were violated. And I think every one of us are opposed to religious liberties being violated. But one example, you said that slave owners flogged slaves for attending prayer meetings. Now, in that opinion, are you suggesting that if the mayor wanted to keep COVID-19 infection rates down to protect his citizens, that is comparable to a slave owner flogging slaves for attending prayer meetings?
Not in any way, Senator. What my opinion attempted to do was to say that the free exercise clause and the right to religious worship is among the apex of rights in our constitutional order. And it's there not because I have put it there, but because the framing generation put it there through the First Amendment. And I believed you couldn't explain the meaning of the Free Exercise Clause without explaining the history of the Free Exercise Clause. And unfortunately for our country, there has been some terrible intolerance toward people of faith. And some of that history informed the writing and ratification of the First Amendment, the history that came before the First Amendment. And some of that history is instructive later because, as Justice Holmes said, sometimes a page of history can be worth a volume of logic.
But Judge, don't you think that such, some would call it overblown rhetoric, might look like you're applying for a job, this job. And I grew up in a family where both my parents had to face religious intolerance. I know it, I've heard what that's like. I believe in the First Amendment. Now, in your judicial investiture, you've spoken about that at some length. I'm just putting, you said we're at risk of losing our courts in our countries. We will not surrender, we wage war. Are judges generally in the position of waging war? And who are we going to lose our courts to in this country?
Well, Senator, the message there and the message throughout my investiture speech was really twofold. The first message was that good judging means taking the judge's personal policy preferences out of the equation and following text, structure, history, and precedent. The second point is that the politicization of the judiciary is harmful to an independent judiciary. And so I wasn't trying to inject politics into my speech. I was trying to push back against the politicization of the judiciary.
Well, you, Judge, you're under oath, so I'll take that as your answer. I'd also note that the statements you made follow the Republican agenda and what Donald Trump wants to see in his nominees, and you can understand why some, including a number of Republican judges, feel that it was more of an audition statement. But my time is up, and Mr. Chairman, I will submit some further questions for the record.
Yes, sir. Without objection, you may do so and introduce your statement also. Senator Cornyn.
Thank you, Mr. Chairman. Judge, welcome. Congratulations on your nomination. I've been amazed that there are members of the Senate and Congress generally who don't think it's okay for us to be here doing our job. They think it's okay for grocery clerks to show up and make sure that we have food on our tables. They think it's okay for doctors and nurses to show up and tend to the sick in our hospitals and healthcare facilities. They think it's okay for police officers to show up, but heaven forbid the United States Congress show up to do our job. And I thought our friend Senator Durbin did a good job of making a long list of things that we can do and that we may end up doing, but you got to start somewhere. And as we know, the responsibility to provide advice and consent on nominations to our courts is one of the most important responsibilities of the Senate. Now, I guess you stand accused of actually knowing a United States senator or two. I don't know how you become a federal judge without knowing a United States senator, since it is the Senate's responsibility to provide that advice and consent. But I would submit that we can walk and talk and chew gum at the same time and do a number of things. And I, for one, am glad to be back. So some have said that you don't have the requisite experience to be on this on the D.C. Circuit Court, and it's true that you did not have an extensive trial practice before you became a district judge. You chose to go into academia primarily, correct?
Yes.
Are there justices currently on the United States Supreme Court who never had an active trial or appellate practice but served primarily in academia?
Senator, it's my understanding that there's a long and rich tradition of academics being nominated to federal appellate court positions. They are on the D.C. Circuit. There are former academics on the U.S. Supreme Court. I'm not trying to put myself in their league, but the answer to your question is yes, there certainly is a long history of academics being nominated to the federal courts.
And I guess you've also been criticized for your relationship with Judge Kavanaugh. You clerked for Judge Kavanaugh on the D.C. Circuit, is that right?
That is correct, Senator.
And I think that the way Judge Kavanaugh was treated during the confirmation process is a stain on the Senate Judiciary Committee and on the United States Senate. It was absolutely disgraceful and completely unjustified. Now, you made some statements in defense of Judge Kavanaugh while you were a law professor, correct? You gave some TV interviews and the like?
I did, Senator.
Is it unusual in your experience for law professors to opine either on judicial nominations or on legal matters that are being considered in the public arena?
It's not at all unusual. In fact, I think I could go so far as to say that for many law professors, it's an important part of the job.
And the news media is always eager to have some law professor who claims some expertise on a topic render their opinion. So did you feel that you were primarily defending Judge Kavanaugh against what you viewed as unjustified and untrue attacks against his character?
Well, when I began speaking about Justice Kavanaugh in the summer of 2018, I did it because as an academic and as a former clerk, I thought I knew about Justice Kavanaugh and his jurisprudence, and I wanted to share that knowledge with people who didn't. There were certainly times when I defended Justice Kavanaugh. Justice Kavanaugh is a friend and a mentor, as is my former boss, Justice Kennedy. I clerked for both of them, and I will defend them both until the cows come home.
And you've been active as a law professor in writing various articles. That's part of what law professors do, right?
It is, Senator.
On a wide variety of topics?
That's correct. One of the focus of my scholarship is or was administrative law, which of course is kind of the day in, day out bread and butter of the D.C. Circuit.
Well, thank you, Judge, for being here and accepting this responsibility. And thank you, Mr. Chairman, for scheduling the hearing. I think it's very important that the Senate demonstrate that we can function, much as many other people in the economy and in our daily life are functioning safely, observing social distancing and all the right guidance from the Center for Disease Control and other experts. Thank you very much.
Senator Durbin.
Thank you very much, Mr. Chairman. And let me say to my friend, Senator Cornyn, I'm here. I'm here doing my job. And I came here because we're in the midst of what this nominee has characterized as an unimaginable crisis. I cannot imagine that I could go throughout the state of Texas or the state of Illinois and ask Americans who are concerned, worried, frightened by the current situation facing us with the coronavirus, what the highest priority of the Senate Judiciary Committee should be. We know what it is when it comes to Senator McConnell. It is this nominee. This nominee. Of all the things that we could be debating, things that are relevant to this crisis, we have been brought back here to debate this nominee. That's the point I wanted to make in my opening statement. I'm here. At some risk, I assume, maybe some danger, I'm here. And many of us are as well. And that's the point I wanted to make. So let me ask you this, Judge Walker. You've been very careful, and I've written it down over and over again, how you've referred to your responsibility when it comes to the Supreme Court decision upholding the Affordable Care Act. And only once or twice have you deviated from saying it is binding on you, quote, as a district court judge. So please clarify, how would it be binding on you, if at all, should you become a D.C. Circuit Court judge?
It would be binding on me in an absolute sense. Vertical stare decisis is absolute, and I would follow all precedents of the Supreme Court fully and faithfully.
But you said, and I quote, I will go where the law leads, I will go where the Constitution leads. Could you square that statement with what you just said?
Oh, certainly, Senator. The Constitution requires absolute fidelity to Supreme Court precedents. The Constitution outlines one Supreme Court and then the possibility of lower courts. And so in the judicial hierarchy, whatever the Supreme Court says, that's the law for a lower court judge, whether I'm on the Western District of Kentucky, as I am now, or if I'm lucky enough to be confirmed to the D.C. Circuit.
The problem we have, Judge, is that we expect of our judges honesty, humility, impartiality. You have not been the least bit impartial when it comes to the Affordable Care Act. Your legal or / constitutional contempt is obvious. You call it an indefensible decision, the decision upholding the Affordable Care Act. Indefensible, your words. At your own ceremonial investiture, with a Supreme Court justice standing by you, you mocked it. You mocked that moment when Justice Kennedy was told what the rationale was for the Affordable Care Act case. And now we're in the midst of a pandemic where the question is being asked by everyone, can I protect myself? Can I protect my family if I have to face this virus? That is a question that people face many times each day. And here you come before us asking for a lifetime appointment to the second highest court in the land, having mocked the law that basically provides an attempt to extend health insurance to more Americans. Do you understand the angst? Do you understand the concern that we have to put you in that position at this moment in history?
Senator, if I can speak personally just for a moment, I know your time is limited. When I was 2 years old, my mom had breast cancer. She's a breast cancer survivor. She's survived heart surgery. She has survived neurosurgery. I thank God every day that she was able to get the medical care that she needed, and I very much hope that every American is able to get the medical care that they needed. As a judge, it's not my job to define policy. It's my job to go where the law leads. And with regard to what you said about integrity and independence and judicial temperament, I think that question goes to why the American Bar Association said they were giving me their highest rating yesterday.
I've got a way to resolve this problem. Let me ask you if you'll consider doing this, put our minds at rest when it comes to what you just said and what you would do as a judge. In light of your public comments about the Affordable Care Act's constitutionality, would you commit to recuse yourself from any case involving constitutional challenges to the Affordable Care Act's provisions?
Senator, Section 28 U.S.C. 455 outlines when a judge should or should not recuse from a case, and I pledge to you today to follow that statute to the letter. I would also consult with my colleagues on the D.C. Circuit and the AO. There is a long tradition of judicial nominees not making a promise on whether to recuse from particular cases, because a judge has to take every case, case by case, with an open mind, and the decision on whether to recuse about a case is a decision about the case.
Judge Walker, after 162 television appearances, after all that you've written and all you've said, it is painful to hear you say you have an open mind on the issue of the Affordable Care Act. I gave you your opportunity to clear this issue off of the agenda. You've chosen not to. I yield.
Senator Lee.
Thank you, Mr. Chairman. Thank you, Judge Walker, for being here. I'd like to state at the outset, I think it is not only acceptable, but appropriate and entirely necessary for us to be here. You've got first responders, firefighters, police officers, doctors, nurses, other healthcare professionals, people who run pharmacies and grocery stores and drive trucks, who've been working 24 hours a day, 7 days a week, even while managing the difficult task of homeschooling their children for the first time. And you've got lawmakers who have been absent in recess for about 6 weeks. It's not to say we didn't have reasons to do that, but my point is this. If you're going to legislate, legislate. If you're not going to legislate, don't legislate. But you can't pretend to legislate when Congress is out of session. Congress cannot, may not, should never attempt to be doing its duty when, in fact, members of Congress aren't here. We can't have hearings. We can't process presidential nominations. Nor can we enact legislation if we're not here. Now, we have in place mechanisms that allow us to socially distance. They're not foolproof, no, but nothing is. We have undertaken every reasonable effort to make sure that senators can convene and do so in a safe manner. I have to say that I somewhat resent the suggestion that because Judge Walker has voiced some disagreement and discomfort with the analysis undertaken by Chief Justice Roberts in his majority opinion in NFIB versus Sebelius, that somehow can be equated with a policy argument, an argument indicating that Judge Walker is somehow apathetic to the needs of individual Americans, to the poorest among us. Quite to the contrary, that's his passion in life, is to serve those who need to be served, even when it's unpopular. For whatever it's worth, I strongly echo the view that it is not the inexorable command of the law to say that a court may never be criticized for making a wrong decision. Our federal court system is a wonder of the world. It's the best of its kind anywhere, not only on this continent, but on any other on this planet. It is nonetheless inhabited and operated by fallible, mortal human beings who sometimes make mistakes. Chief Justice Roberts and the rest of the majority opinion in NFIB versus Sebelius made a mistake. Now, one can say that, as you have said that, without commenting on the underlying policy merits, without commenting on who ought to have health care. It is a fact. It's a fact evident on the pages of that opinion itself that Chief Justice Roberts, in authoring the majority opinion, rewrote the Affordable Care Act not once, but twice, in order for it to say what it did not say when it was enacted by the Senate, in order to render constitutional otherwise unavoidable constitutional defects. Judge Walker, recently you issued a temporary restraining order in a case involving religious liberty in Kentucky. You've been widely criticized for that opinion. That opinion is, in my view, entirely consistent with the law. Is it, in fact, not an unremarkable proposition of the law to say that a government may not single out religious activity and religious expression and uniquely target religious activity and religious expression for adverse treatment by government, as it was done in the case of the city of Louisville?
That's absolutely correct, Senator Lee.
That's black letter law, right?
It is black letter law under Supreme Court precedents and under Kentucky's Religious Freedom Restoration Act. It is absolutely the command of the Constitution that secular institutions and religious institutions be treated equally by the state.
Such that your failure to act in that circumstance would have been a dereliction of your duty and of your oath to uphold, protect, and defend the Constitution of the United States.
I believe that's correct, and I would also add that I think if I had waited longer, there would have been irreparable injury to the plaintiffs, which is part of what the four-factor temporary restraining order test requires a judge to consider.
If you're confirmed to this position, you'll be serving on the U.S. Court of Appeals for the D.C. Circuit, which specializes in administrative law. Administrative law has a long and interesting history in this country, and administrative law often focuses on the principle that Congress may not simply enact a law empowering the President of the United States or any executive branch officer to simply promulgate and interpret and enforce rules carrying the force of generally applicable federal law as may be deemed appropriate within the executive branch. How do you think that might play into your work on the U.S. Court of Appeals for the D.C. Circuit?
Well, Senator Lee, under the non-delegation doctrine, Congress cannot delegate its legislative authority to an administrative agency, and that goes back to the first sentence of the first article of the Constitution, which says, all legislative powers herein granted shall be vested in a Congress.
Thank you very much. I wish we could talk longer. I hope we'll get a second round, but I've enjoyed visiting with you. Thank you.
I believe Senator Whitehouse is by video conference. Is that correct?
Here I am. Is this working?
We hear you, now we see you.
Oh,
Thank
great.
you. The floor is,
Thank you,
floor is
Chairman
yours.
Graham. I appreciate this new technology, kinda.
You look great.
Oh, thanks. Judge Walker, you recently signed a letter to the Code of Conduct Committee, along with many other judges. You did not provide that letter to the Senate. Why did you not provide that letter to the Senate in answer to question 12C?
Senator, that letter was a letter from judges to judges. There were approximately 200 current federal judges nominated by every president going back to Gerald Ford, who signed that letter in response to a request for a response from the Code of Conduct Committee. And it wasn't a public letter. It was, again, of the same nature of any kind of correspondence from one judge to another judge or a group of judges to a group of judges.
So you think it was not an official statement or an other communication relating in whole or in part to matters of public policy or legal interpretation?
Senator, again, as I said, I think that judges frequently write to other judges. I do it by email sometimes. I do it by handwriting. I'm sorry,
Are
Senator.
there other things not disclosed?
If you could repeat the question, I'm sorry, I missed it.
Are there other things you have not disclosed that are at all like this particular letter?
There are not.
This is the one, then.
Senator, I have disclosed everything that the Senate committee has asked that I disclose.
Yeah, well, did you have any role in preparing this letter?
Senator, I saw a draft of the letter. However, the short answer is no. I didn't write anything that's in the letter or make any edits to the letter. I was proud to sign the letter.
Who prepared the draft of the letter?
Senator, it's my understanding that there were a handful of federal appellate judges who prepared the letter. I'm not really
They are.
I'm not sure it's my place to say who drafted the letter, although I suspect they would be quite proud to be listed as some of the drafters. If you'd like, in the follow-up questions, I'm happy
Is there a
to.
privilege of some kind here?
I'm sorry?
Are you answering this question?
I'm sorry, what was your question?
Is there a privilege of some kind here? Why are you not answering my question?
I guess actually, Senator, as I think about it, my best guess is that the judges who drafted the letter would be proud to be known as having drafted the letter. And so the two that I know who were involved in it were Judge Katsas and Judge Thapar. They are two judges that I greatly respect and admire, and I agreed with the letter that they drafted, and so I signed it. My understanding is there were some other judges involved as well, but those are the judges
Those are the two you recall.
I'm sorry?
Those are the two you recall.
Those are the two that I recall with certainty.
Can you tell me, in your advocacy on behalf of Brett Kavanaugh, who coordinated your TV and radio appearances?
Yes, Senator. In the vast majority of those TV appearances, I received a direct email from the TV producer, and they asked if I would be willing to share my experience about Justice Kavanaugh, and I was willing to do it.
Were there no intermediaries between you and the media during this period?
An old friend of mine, on a volunteer basis, made a few emails early on, but again, it was quite informal. I was new to the world of cable news, and it was an unfamiliar position for me. I was asked to make statements about a justice who I greatly admire and who I consider a mentor and a friend, and I was happy to do it.
Who was the old friend?
You know, Senator, my old friend Matt Latimer, if he's a good person, and he has certainly more knowledge about the world of cable news than I do, and he did it without pay, and he did it because he likes me, and I did it because I admire Justice Kavanaugh.
And he was the only person who coordinated or prepared or advised your TV and radio appearances?
That's correct, Senator. Certainly to my knowledge, that's correct.
So last question, what war is Judge Kavanaugh waging that you referred to in your remarks when he came to your investiture?
Well, Senator, the remarks that you're referring to, as well as other statements in my investiture speech, were my description of the kind of justice that I believe Justice Kavanaugh is and the kind of good judging that is required of all judges, and that is fidelity to the separation of powers, to text, and an understanding that the judge's role in our Constitution is a limited role, that it's for the political branches to make policy, and it's for the judges to decide cases without passion or prejudice for any particular policy outcome.
And you described that as waging war, correct?
Senator, again, in my speech, I was admittedly unabashed in my defense of a judicial philosophy and an approach to judging and the rule of law that considers the original meaning of text and keeps judges' politics out of decision-making.
Mr. Chairman, you've let me go over my time. I am grateful to you. I appreciate it. I wish we had more time. And clearly, we will have a lot of questions for the record that I hope we'll get complete and candid answers to.
Yes,
Thanks
sir.
very much.
Thank you very much, Senator Whitehouse. Senator Cruz.
Thank you, Mr. Chairman. Thank you for convening this hearing. And I suppose I should congratulate Judge Walker on having what I'm pretty sure is the largest judicial confirmation hearing we've ever had. Albeit sparsely attended, but congratulations on your service on the district bench, and congratulations on your nomination to the D.C. Circuit. You recently had before you a case concerning religious liberty. Can you share for this committee your view of what the Constitution is protecting with the religious liberty clauses of the First Amendment, and what is the importance of those protections?
Certainly, Senator Cruz. The freedom to worship was one of the audacious ideals of our Constitution. The history of the world is rife with religious conflict and religious persecution, and our framers made the decision that no matter what God you pray to, no matter where you worship, you should be equal in the eyes of our law. As I said, it was an audacious decision. They put it in the Constitution both because they knew that people of faith had faced discrimination in our past, and because they were concerned that they might face discrimination in the future. And unfortunately, as I said in my opinion, there have been unfortunate chapters in our history where that has happened. But the Supreme Court has said over and over again that the law requires secular institutions and religious institutions to be treated equally. And that was the fundamental principle at the heart of my temporary restraining order.
Judge, our country is obviously in a time of crisis right now, and times of crises bring out people's character. We have seen some extraordinary government policies implemented. During crisis, there are legal authorities for government to act. But what is your view of the extent to which the Bill of Rights continues to operate and protect our liberties, even in the time of crisis?
Senator, there's case law on this question, and the case law suggests that constitutional rights don't stop being constitutional rights, even in a time of emergency.
You've written at some length about separation of powers. The D.C. Circuit has a unique docket with the heavy assortment of challenges to decisions from federal agencies, independent agencies, and questions of separation of power get raised with some regularity at the D.C. Circuit. Can you share with this committee your views on why separation of powers matter and what it does for the average American citizen?
The separation of powers protect liberty. Of course, there are provisions in our Bill of Rights, including the Free Exercise Clause, as we were just discussing, that are important protections of liberty, but there's probably no more important protection of liberty than the separation of powers, because there are tyrannies all across the world and all throughout history that have beautiful bills of rights, but they don't have the separation of powers. They concentrate power in one branch of the government, and at tyranny's worst, in just one person. And when that happens, there's no check on that person, and so whatever nice liberties are listed in a Bill of Rights, the person with the concentrated power is free to ignore them. There's probably no more dangerous threat to our liberties than the concentration of the executive power, the legislative power, and the judicial power all in one place. Separation of powers protects against that, as you, Senator Cruz, have written before, as the Federalist Papers have said, and have other senators on this committee have written about.
So let me ask, not just on the horizontal axis, but on the vertical axis as well. Describe to this committee your views on federalism, the importance of federalism, and why it matters for individual liberty in America.
Well, it's essential, Senator. As Justice Kennedy once wrote, part of the genius of our framing generation is that they split the atom of sovereignty, and they created a sovereign federal government, but the states maintained a certain sovereignty themselves. And that, as you say, vertical separation of powers protects against the concentration of power in any one place. And there is our nation's probably greatest protection of liberty and against tyranny.
Thank you.
Senator Klobuchar, I think, is by video conference.
Yep. Thank you, Mr. Chairman.
Yes, ma'am.
And also thank you for being willing to do a hybrid hearing like we're seeing today.
Yes,
Senator Blunt and I in the Rules Committee worked hard to get this done, and I'm glad that we are seeing senators there as well as remotely, so thank you. I think we should be devoting one of our first hearings to something else, and that is the pandemic. With the jurisdiction of our committee, has been pointed out by some of my colleagues, we could be talking about things and focusing on things like the over 2,000 people in our prison that have the virus. Over 40 of them have died. Our jurisdiction over immigration, our jurisdiction over the issues of domestic violence and sexual assault. We just had a case in Minnesota in the suburbs where a man killed his wife, strangled her, and hid her in a crawl space in their house. There is a lot going on in our country right now, and I hope we will have future hearings focused on things like this. Now, we can't divorce this nominations proceeding from the pandemic, and I guess that's my first question of you, Judge Walker. In July 2018, you wrote an op-ed in which you were critical of the majority of the Supreme Court, including Chief Justice Roberts, that, in your words, catastrophically accepted that the Affordable Care Act was constitutional under the Congress's taxing power. Do you still hold this view?
Senator, the statement I made was made as an academic and as a private citizen engaging in matters of public concern. And my role now as a judge is not to give a thumbs up or a thumbs down to particular Supreme Court precedents. NFIB v. Sebelius is binding Supreme Court precedent. If I'm lucky enough to be confirmed to the DC Circuit, it will be binding on me. And in my current role as a district judge, it's binding on me absolutely.
And you do understand that right now there are Americans that are depending on the Affordable Care Act. And the way I look at this is, if none of this stuff is relevant that you did as a private citizen, you've only been a judge for 6 months. And in your adult life, since you're 37, that is 2 to 3% of your work life. And so, in other words, 97% to 98% are off limits. I don't really understand that. I think that's the only way we're going to figure out your views as we evaluate what kind of judge you would be. And I think another example of this is you provided the committee with a working draft of a law review article you wrote earlier this year, where you said that the Supreme Court will be headed to reconsidering the Chevron doctrine, which says the court should generally defer to reasonable interpretations, as you know, of agencies and things about protecting our drinking water, safe workplaces. So do you think that a court, single judge, is better positioned than an agency expert to interpret a rule on things, complicated issues of water safety or on worker protection?
Well, Senator, the article that you're referring to describes and predicts what the Supreme Court has done in the past. It describes and where it might go, it predicts. And in fact, as I was writing that article, one of the predictions I made with regard to deference to agencies involved a case called Kaiser v. Wilkie. And when I started drafting the article, I predicted that the Supreme Court would address deference to agencies and perhaps do it in a slightly different way. And by the time I'd finished drafting the article, Kaiser had been decided. And the decision in Kaiser didn't overturn any precedent, but it did refine and in some ways limit the precedent that was at issue there with regard to deference to agencies. And so to the first part of your question, I'm not in any way running away from the scholarship that I wrote as an academic or asking you to ignore it. I hope that you will, I don't think it's been read very much until now, but if you do read it, I hope that you see that there's a rigor to the analysis and the research and the writing that reflects how I would approach every case, case by case, with an open mind, trying to look at things from all sides and trying to do what good judges do, which is dive into an area and try to learn as much as I can about it.
Judge Walker, but so the way I see this is about a third of the cases of the DC Circuit are about agency appeals. And so it's a really important part of the work. And my concern here is that your views are not consistent with where the courts have been, including where actually Justice Scalia was when it came to Chevron, and that will dictate how you're going to be as a judge. And just one last point I want to make about this. The nonpartisan Brookings Institution report back in October of 2018 found that the Trump administration has between a 5 to 10% success rate when defending the administration's actions in court. Now, previous administrations have had averages of 69%, and that includes Republican and Democratic administration. So to me, this suggests that even under Chevron deference, courts actually can prevent agency actions that are unreasonable or contrary to congressional intent. And this may be an academic argument, but for me, it's a real thing. My grandpa worked in the mines. It was agency rules that made those mines safer. I think a lot of people during this pandemic who are working in the meat packing plants right now in my state, or people who are working in the front lines in the hospitals, get that these OSHA rules and some of the safety regulations in place are going to make the difference between life and death for them. And I want you to consider this as you answer this question and you think about how you're going to rule on these things in the future if you are confirmed.
Well, thank you, Senator. I think the role that agencies play in our country is an important role in terms of the kinds of protections you're talking about. It's not for me as a district judge to say what certain policies should be, but I think I can say that our country is stronger when we have a healthy workforce and when people are safe. I think in terms of judges reviewing agency action, it's never the role of a judge to second guess a political policy decision of an agency, particularly when that agency's decision comes from the agency's expertise. However, it is always the role of a judge to remember the court's responsibility under Marbury versus Madison, which is to say what the law is. And when an agency issues a regulation that has not been authorized by statute, a judge has a responsibility to say that that agency regulation is invalid. It may be great policy, but a judge has to sometimes issue decisions that result in a policy outcome that the judge doesn't like. And if a judge never issues a decision that results in a policy outcome that the judge doesn't like, it's probably not a very good judge.
Yeah, and of course, my problem is, and I've run out of time here, but other things you've said, which could throw out the Consumer Financial Protection Bureau, the FTC, when you've been critical of the Supreme Court's decision in Humphrey's Executor, to me, that results in decisions that are not good and will hurt people. But I will follow up with that in writing or if there's a second round. Thank you.
Thank you. Senator Hawley.
Thank you, Mr. Chairman. Judge Walker, nice to see you again. Thanks for being back before us. Let's go back to religious liberty, if we could, for a second. Let me ask you about one of the seminal religious liberty cases of the last several decades, Oregon versus Smith, a case that I know that you're familiar with. I wonder if I could ask you to start by just telling us what you understand at this remove to be Smith's controlling holding. What remains? Let's assume that you are confirmed. You're already a sitting judge, but if you're confirmed as a federal circuit court judge, what would you understand to be Smith's direction to you that you are bound to apply?
Well, Senator, Smith preceded Lukumi Babalu, and it, of course, preceded Trinity Lutheran, which I know you're extremely familiar with. And the scope of Smith after Trinity Lutheran, how to read Smith in light of the majority's opinion, what to do with the concurrence in Trinity Lutheran. Of course, concurrences are not binding precedents. It is an issue that is being litigated throughout the country. It could easily come to me in my current role as a district court judge. I'm hesitant to say more than this, that Smith is still good law, but Trinity Lutheran is a recent decision that every judge in the country must follow fully and faithfully.
Let me ask you, since you mentioned Trinity Lutheran, the Hosanna Tabor case, let me ask you about that. Let me ask you about actually Trinity Lutheran in a second. Let me first start with Hosanna Tabor, which also involves Smith. The Hosanna Tabor case was a case that was the majority opinion. The unanimous opinion was written by the Chief Justice. He has something to say about Smith in that case. There he says that Smith, and I'm quoting now from the majority opinion, the court's opinion, Smith involved government regulation of only outward physical acts. The present case, in contrast, concerns government interference with an internal church decision. What do you, this is certainly binding precedent. What do you take that to mean? I mean, if you've got to apply that, and you may well have to, what do you take that to mean?
I take Hosanna, and I was clerking the year of Hosanna Tabor. I take the decision to mean that it is not the place of the government to tell a church who the church's minister should be. And as you point out, it was a unanimous decision.
What do you, if Smith governs, if the Smith rule is generally and neutrally, generally applicable laws, neutral and generally applicable laws, but church decisions are carved out, I mean, what remains of Smith in your estimation? Does it just mean that when it comes to internal church decisions, the Smith rule doesn't apply? Is that your understanding of the doctrine? I'm not asking you to predict where the court's going to go. I'm just trying to search for what you think you are bound to apply right now. And then I want to ask you about Trinity Lutheran.
And so, Senator, as you know, one case that's currently being litigated before the Supreme Court right now is the Blaine Amendments case. That case, other cases throughout the country involve a lot of the questions that you're getting at. So I want to not cross the line of saying something that the Code of Judicial Ethics prohibits me from saying, but I do want to answer your question. There is nothing about Smith that allows the government to dive into the inner workings of a church or synagogue or mosque and tell those people of faith who their faith leader has to be.
Let's come to the Trinity Lutheran case now. And you said just a moment ago, I think significantly, that Smith is binding precedent. The Supreme Court certainly has not overruled Smith in any way, shape, or form, but you also said that Trinity Lutheran is binding precedent and must be applied. So tell us what you mean by that. What do you think out of Trinity Lutheran, again, a case that would be binding upon you, what do you feel, what is the instruction there that you would feel bound to apply that you can be certain of as a circuit court judge have confirmed?
Senator Hawley, the Constitution commands at least this, that the government treats secular institutions and religious institutions equally. And what was going on in Trinity Lutheran, as you know well, is the government had a general program. It said, any comers may apply unless you're a church. And the court held in Trinity Lutheran that the government was treating religious institutions differently than secular institutions, and they held that that was illegal.
Finally, in my remaining few seconds here, you clerk for Justice Kennedy. Do you have a favorite opinion of the justices?
I'm the father of an only daughter, so I never have to worry about being asked who my favorite child is. But along those lines, I'm not going to pick a favorite opinion of Justice Kennedy's. I certainly admire him and am very grateful for the role that he played in my life.
Thank you, Judge Walker. Thank you, Mr. Chairman.
Senator Coons.
Mr. Chairman, we are here in the middle of both a health care and an economic crisis. And as has been observed by many of my colleagues, we should be holding a hearing that responds to that pandemic crisis and the health and economic crisis. I have tried, but it is not responding. Is it on? Thank you, ma'am. Mr. Chairman, if I could, we should, in the middle of a health care and an economic crisis, not be having a hearing on a partisan judicial nominee for a vacancy that won't even be available for 119 days. In the last 119 days, 250,000 people have died around the world, and America now has more deaths than any country in the world, 1.2 million cases and 70,000 deaths. And some of my colleagues have compared our service here today with the service of first responders responding to an emergency. This is not an emergency, but it's clear it is the top priority of the majority leader to have this entire Judiciary Committee and all of the workers who were called back to this Capitol and all of our staff who were called back here so that we could have this confirmation hearing, which I frankly think should not be anywhere near our first priority in response to this national health pandemic. If I could, Judge Walker, in an article you wrote in 2018, you said the Supreme Court's decision upholding the Affordable Care Act is indefensible, the taxing clause rationale weak, and its acceptance catastrophic. As we sit here today, the Trump administration continues to argue that courts should strike down the Affordable Care Act. Do you stand by your description of the decision upholding that act as indefensible?
Senator, as I said earlier, the decision at issue there in NFIB v. Sebelius is 100% binding law as me as a district judge, and it would be.
You have stated that. Will you still stand by your public assertions, your advocacy, that its decision is indefensible?
And while I made statements as an academic and as a private citizen, I don't think it's appropriate now for me as a sitting judge to go beyond what I said in my role at the time.
I'll just say that you yourself said earlier, a judge must approach every case with an open mind. And in your exchange with Senator Durbin, I'm left questioning why any litigant would trust you to be open-minded and fair in deciding a case about the ACA, given your previous advocacy. In a 2018 article, you wrote the FBI as an agency should not be independent, and the director must think of himself, and I think I'm quoting, as an agent of the president. In my view, that is an over-sweeping view of executive authority. Could a president, in your view, appropriately direct the FBI to investigate his political opponents?
Senator, the article in question is really a historical exploration of the FBI's infringements on civil liberties, and to the extent your question goes to the role of the relationship between the president and the FBI with regard to the liberties of political minorities, I argued in the article, before I was a judge, I argued in the article that it was the very lack of supervision by presidents during Director Hoover's tenure at the FBI that allowed some of the worst civil liberty abuses in the...
While I may agree with your characterization of the lack of appropriate oversight that tolerated or permitted Hoover's overreach and the FBI's inappropriate actions, I'll just remind you that contemporaneously, roughly in September of 2018, after John Dean testified at then Judge Kavanaugh's hearing, you called John Dean a disgraced lawyer. This is on Fox News, I think. You said, and I quote about John Dean, "This is the man who betrayed his country and then betrayed his friends. He's not fit to touch Judge Kavanaugh's shoes." Given the context, I consider John Dean a hero for telling the truth about Watergate and exposing the ways in which the Nixon administration and President Nixon inappropriately used his power as president in ways that were historic in their overreach. So given this context where you've said that the FBI should consider itself as an agent of the president and you've attacked John Dean as someone who betrayed his country and then betrayed his friends, please help me understand why you made that comment about John Dean and what that should tell me about your view of independence of the FBI and appropriate actions by a president.
Senator, I absolutely love American history, and I mean this sincerely. I know there's you may not believe me.
There's a senator here who will say they hate America.
No. I just mean, I want you to know what I'm about to say. I'm sincere. I would relish the opportunity to sit over lunch and talk American history with you and share your opinion and my opinion. I think part of what makes history so much fun is that people can have different opinions and different perspectives. Sitting here as a sitting district court judge, I don't think it's appropriate for me to comment on John Dean, but whether I'm lucky enough to be confirmed or not, I would love to talk Watergate history with you, and I'm quite sure I would learn a lot.
I'll move to a last question, if I can, Your Honor. The ABA found you were not qualified for the judgeship you currently hold due to a lack of trial experience. When I asked you written questions about motions, arguments, trials in federal court, you were clear that you had never performed these critical tasks. So I'm bluntly left wondering why you're getting a promotion to one of the most important courts in our entire federal system. At your investiture, you said, although we celebrate today, we cannot take for granted tomorrow, or we will lose our courts and our country to critics who call us terrifying and describe us as deplorable. Who is we in that statement you made at your investiture?
Senator, in that part of the investiture speech and in others, I was talking about those who approach judging with the respect for the rule of law and the separation of powers and fidelity to text and the belief that a judge should say what the law is and not what he or she thinks that the law should be. And with regard to the first part of your question about the ABA's rating, I do think there's a reason that yesterday the ABA gave me their highest rating of well-qualified based on my experience, integrity, and temperament.
Well, my concern is that as a sitting judge, you seem to have thought it was appropriate to talk about winning a battle for the courts and have conveyed yourself and your opinions across a number of different topics, texts, and times that does not create the sense of an unbiased approach to critical and key questions. I recognize I've exceeded my time, and I will thank the chairman for his patience, but you know, I frankly, at a time when we have lost more Americans than died in the Vietnam War in a national health pandemic, I don't see the urgency of this confirmation hearing. Perhaps we will have that chance to debate American history, but I feel a sense of urgency about the application of principle to the future and respect for precedent, and I'm gravely concerned about where you're headed on those trajectories. I'll have more questions for the record. Thank you.
Thanks, Senator Coons. Senator Tillis.
Thank you, Mr. Chairman. And I want to, for one, thank you for holding this hearing. I also want to thank you for I want to thank all the staff who made this possible, including your staff who made this video link possible. I'll be on the Hill in a few minutes voting. I respectfully disagree with my colleagues who think that we shouldn't be having this hearing. We need to have this hearing and hearings on many of the topics that Senator Klobuchar and others mentioned. And I would add, I'd like to add a hearing or a focus on liability protections, because we're going to see a wave of lawsuits here, people taking advantage of a situation that was through nobody's fault. So I, for one, think we need to get a regular order where we're encouraging states to try to get back in business safely. I think that we're trying to demonstrate that we need to as well, and I respect everything that you've done to make this happen. Judge Walker, on the Fisher case, I was just kind of curious. You tailored your opinion to that specific case. Why not do what a lot of other district court judges are doing and just issue a national injunction, because these same debates were going on across the country? Why did you decide not to do that?
Senator, I did issue a narrow injunction in that case. I cited Supreme Court precedent that at least strongly suggests that when a judge issues an injunction, the injunction should be no broader than necessary in order to provide the relief that the plaintiffs in that particular case were seeking.
Well, Judge, even though I would have been sympathetic and to the arguments from a number of other churches across the country at the time, I think you did it exactly right, and I appreciate you doing that. I also think that there is a battle that we all have to recognize here, or a real threat to our independent institutions, and that's when we have people come to you, as has been done in this hearing, and really encourage you to legislate from the bench. I recognize that we have a healthcare problem. I, for one, filed a bill on protecting pre-existing conditions that for the life of me, I cannot get Democratic support so that we can put that to bed. But I don't think, do you think, you mentioned actually the experience that your mother had. So you've got a certain empathy towards people who need healthcare, who need access to healthcare. Do you think that that empathy should in any way influence your decisions, which I believe should be based on the plain letter of the law?
Thanks, Senator. As I said earlier, and as you were referring to, I do have a lot of empathy for anyone who was in the terrible medical condition that my mother found herself in. At the same time, a judge has to go where the law leads with respect to what the Constitution says, what statutes say, what precedents say, and a judge has to make those decisions even if the judge would prefer that there were a different policy outcome as a result.
A more basic question. Why do you want to do this? You're young, you're extraordinarily talented, you have so many other options. Why do you want to be a circuit court judge?
Well, Senator, the opportunity to serve the country from the D.C. Circuit is the opportunity of a lifetime. Growing up, Louisville, Kentucky, if you had told me I'd be nominated to the D.C. Circuit one day, I think I certainly wouldn't have believed you as a little kid. I saw as a clerk on the D.C. Circuit what kind of judge then Judge Kavanaugh was. I saw what kind of judge Judge Griffith was, the judge who I've been nominated to replace, who I have the highest respect for. These were people I really admired, and I feel overwhelmed with gratitude to be nominated to sit on the same court that they sat.
Judge, you've demonstrated incredible poise in this hearing, and I appreciate everything you're doing. I look forward to supporting your nomination. Thank you, Mr. Chairman.
Thank you. Senator Blumenthal.
Thanks, Mr. Chairman, and I want to join in thanking you for your conducting this hearing so flexibly and fairly. Welcome to the committee, Judge Walker. You know, I want to join in thanking not only the first responders, our fire and police and healthcare workers around the country who are on the job today, but also our police, the Capitol Police, all of our staff who are making it possible for us to be conducting this hearing and votes during this week. Judge Walker, I've been a law clerk as well. I know about defending mentors and former bosses. I clerked for a now circuit court judge and a Supreme Court justice. But defending a judge doesn't mean you have to speak derisively and disrespectfully about the Supreme Court Chief Justice, as you did in your investiture. And it doesn't mean that you have to refer to a Supreme Court opinion as indefensible or catastrophic. You can be critical without being disrespectful. What I think is indefensible is that we are here in the midst of a public health crisis, considering the nomination of someone who would dismantle a healthcare system that is saving lives right now. What I consider indefensible is that we are failing to strengthen that healthcare system and our economic remedies at a time when the nation desperately needs that action. And instead, we're considering your nomination. And what I consider indefensible is that you have taken a position passionately that would deprive many of those frontline healthcare workers, the nursing home clinicians and others, of their health care. And I know that you continue to believe that the Supreme Court decision preserving the Affordable Care Act is indefensible, because in that same investiture speech cited to you by Senator Coons, you also thank the folks who opposed your nomination, including the American Bar Association, by saying, quote, "Thank you for serving as an enduring reminder that although my legal principles are prevalent, they have not yet prevailed. That although we are winning, we have not won." And Although we celebrate today, we cannot take for granted tomorrow, or we will lose our courts and our country. My legal principles continue to believe, are your continued belief, that that Supreme Court decision was indefensible and that our health care system under the ACA should be dismantled. So I want to introduce you to someone who would be directly impacted by the prevailing of your legal principles. This is one of my constituents, Connor of Ridgefield, Connecticut. He's now 9 years old. I met him when he was 5. He suffers from Duchenne muscular dystrophy, a condition that is fatal usually by the time people are 20 years old. It deprives them of their strength and their ability to move, and it is treatable only with very expensive health care therapies that cost tens of thousands of dollars a year. And he is a beneficiary of the Affordable Care Act. He is a warrior. He's a fighter. That's why he's still alive. And he's become a fighter for the Affordable Care Act. And he is one of 1.5 million people in Connecticut, including 182,000 children. These are real people with real faces and real voices, like Connor, who would lose their health insurance because they suffer from pre-existing conditions under your legal principles that you continue to passionately espouse. I recognize you've said that you would be bound by Supreme Court decisions, but that's not what you said when you became a judge and when you referred to my legal principles prevailing. So my question to you is, do you continue to believe in those legal principles, you personally, that the Supreme Court decision upholding the ACA was indefensible?
Senator, Connor is a hero. I can't imagine the courage it takes to be a kid in his shoes and having to overcome the obstacles that he's already overcome at an age like that. I've never had to do that, and I'm in awe of kids like that and people like that. When I was a little kid, I do know my mom had a lot of sleepless nights as a single working mom, often working 2 jobs, trying to figure out how in the world her son, who she loved, was going to have things like health insurance. And I wish badly that she had never had to have those sleepless nights. I wish badly that Connor will always have all the medical care that he needs. And it is for you and for the political branches of the governments to make policy consistent with our Constitution that it makes health care more affordable and more accessible. And I've never...
And we did that, Judge. We did that in the Affordable Care Act, which you would strike down if you had the chance.
And if I can finish, Senator, I've never spoken against the Affordable Care Act as a matter of policy. I said in my answer a moment ago that Congress has a role to play in making, I think all members of Congress would say they have a role to play in making health care more affordable and accessible within the limits of the Constitution. And before I was a judge, before I was nominated to be a judge, I spoke not about the policy merits of any healthcare proposal or any healthcare statute. I talked about a legal analysis regarding the limits of Congress's power under Article 1 and in relation to the kind of vertical separation of powers between the federal government and the states that lie at the heart of what keeps us free. And at no point did I ever wish any ill will toward people like my mom when she was struggling financially, or for heroes like Connor.
Thank you.
My time has expired, and I have other questions which I'll pose in writing, but I don't think Connor would be satisfied with that answer, and I don't believe the majority of the American people would be either. Thank you, Mr. Chair.
Thank you. Senator Ernst.
Thank you, Mr. Chair, and I appreciate having this hearing here today. I'm glad that we are able to gather in whatever means necessary to keep the people's work moving forward. I want to thank Leader McConnell as well for bringing us back into session. We require our essential workers to be out on those front lines every day, keeping America moving, and I believe we have an obligation to the people we represent to be here to do the people's work. So I believe that leadership absolutely is key here, and that we are not asking our constituents to do something that we ourselves are not willing to do. So thank you very much, Judge Walker, for being here today as well. I really appreciate being able to see you face to face. Thanks for taking the time to come here and meet with us in person. You just mentioned a little bit ago something about your mother as well, a single working mom, and that a number of years ago you would never have imagined that you would be in this position today. And I think that speaks volumes as to the kind of country that we live in, that we can overcome certain obstacles in our lives and come from humble beginnings to serve in the greatest of positions. So it is an honor that you have been nominated to serve on the Court of Appeals for the District of Columbia. And I am not going to ask about particular cases. I think a number of my colleagues have done that. But what I do hear from people in Iowa, they want to know the basics about their judges, what those judges represent, and what values they will bring into their position. And although the D.C. Circuit typically takes up cases of administrative law, I do believe that judges who serve on this powerful court, they need to share the same values and morals as any other judge serving in any other position. And so what matters to me and matters to the people of Iowa isn't necessarily the political leanings that so many folks will focus on, but your judicial philosophy. What is your judicial philosophy? That's what I want to talk about today. So bottom line, this is what Iowans ask me, are you an originalist? And can you explain that to me and why that would be important to the people of Iowa?
Thank you, Senator. I don't in any way run away from the label of being an originalist.
Thank you.
I do think that sometimes labels can be overbroad and can confuse more than they clarify. However, I absolutely am unabashed in my belief that a judge must look at the original meaning of text and must go where the text is and be bound by the text, as well as structure, canons of construction, relevant precedents, because it's not the job of a judge to say what he thinks the law should be, what she thinks the law should be. It's the job of a judge to say, here's the law that Congress passed, and to then apply that law as it was written.
So you're not just going to take something that happens in the media or news and say, oh, I think it should be this way. I think the law should evolve, and so I'm going to assist it along its way. Is that correct?
Senator, as I've said a couple times and would gladly welcome the chance to reiterate, a judge is not a good job. A judge is not a good judge if he or she always likes the policy result that comes from the decision.
Very good. Well, and I appreciate that. I think it is important to know that you are an originalist. Folks in Iowa will appreciate the fact that you are an originalist and that you will follow the text of the law, the intent of that law as written. I do wish you well moving forward, and I would give you any opportunity to make any remarks that you may not have had the opportunity to earlier.
I appreciate it, Senator. I know the committee's time is valuable, and I'll stand on what I said.
Very good. Congratulations.
Thank you.
Thank you very much.
I believe Senator Hirano is with us by video conference.
Thank you, Mr. Chairman.
Yes, ma'am.
This pandemic is far from over, clearly because our committee is taking appropriate precautions in having this hearing. So nobody is talking about not wanting to do our jobs. We do object to the subject of this hearing because rather than dealing with issues that have to do with the pandemic and the crisis, healthcare crisis facing our country, we are having a hearing for a nominee whose the seat that he would want to occupy is not even open until September. So this committee's priority in pushing through as many far-right, ideologically driven nominees as possible for lifetime appointments to the court continues with this hearing. I have a few questions for this nominee. I'll start with the two basic questions I always ask, and I just wanted for the record. Judge Walker, since you became a legal adult, have you ever made unwanted requests for sexual favors or committed any verbal or physical harassment or assault of a sexual nature?
No, Senator.
Have you ever faced discipline or entered into a settlement related to this kind of conduct?
No, Senator.
In July 2018, the Baltimore Post-Examiner reported that you advocated for then Judge Kavanaugh to be a Supreme Court justice, arguing that he would, quote, shift the court dramatically to the right, end quote. You said, again, I quote, this is a conservative revolution as big as the Reagan Revolution. Issues like affirmative action, school prayer, gun rights, and abortion will see drastic changes. I predict an end to affirmative action, an end to successful litigation about religious displays and prayers, an end to bans on semi-automatic rifles, and an end to almost all judicial decisions allowing abortion. Basically, that's what you meant. So go on to quote you, this change will give Donald Trump the most conservative judicial legacy of any Republican in history by far, end quote. Do you consider yourself part of this conservative revolution?
Senator, the remarks that I made before I became a judge in the summer of 2018 were meant to be descriptive of Justice Kavanaugh's jurisprudence and predictive of what kind of Supreme Court justice he would be. And I think that my descriptions and predictions were consistent.
Judge Walker, you're not answering my question. You know, you framed this as the most conservative judicial legacy of any Republican in history by far, talking about a conservative revolution. And my question is, do you consider yourself part of this conservative revolution? Yes or no? You don't need to go into a big explanation.
And Senator, as a sitting judge and as a judicial nominee, it's not appropriate. In fact, I'm prohibited from the canons of judicial ethics from commenting on politics or matters of public concern. The predictions I made about Justice Kavanaugh were, I think, consistent with similar predictions that people left, right, and center
Walker,
were
you're
making.
Reiterating, it is very clear you don't want to answer the question. I think we can draw our own conclusions by the statements you've made, the writings you've made, the many, many TV appearances you've made in support of the kind of conservative judge that Justice Kavanaugh is. Next question. As a judge, would you agree that it is important to get all the relevant facts before making a decision?
Senator, it's certainly important for a judge to consider all facts that are in the record before making a decision.
Oh, well, sometimes a judge doesn't allow the record to be complete. So I would say that your answer must be yes, that a judge should consider facts. And to get those facts, would you agree that it is important to hear from all of the parties in a case?
Senator, certainly it's my preference as a judge when time allows to consider all adversarial briefing and to have hearings, as I often do. There are rare occasions when there is imminent, irreparable injury to a plaintiff
all
and
right.
judges.
Let me get to the, excuse me, Judge Walker, let me get to the crux of this matter, because while it is very important for a judge to hear from all parties in a case, that is not what you did in the case On Fire Christian Center. You deliberately excluded one side. You issued a TRO against the city without providing the city notice of the case or an opportunity to present the facts. And according to local news reports, the city tried to contact you twice, but was unsuccessful. And you say that there was an exigency, there was no time, and yet you had time to write a 20-page opinion on your TRO with 84 footnotes. It is not credible to me that you didn't have time to give the city an opportunity to present the facts, and they tried. That shows me how important facts are to you as a judge. My time is up.
Chairman, may I quickly answer?
Very quickly.
Senator Hirono, the mayor's lawyers confirmed at a hearing a couple days after the TRO that the mayor was mistaken when he said that he had tried to contact the court. At no point did the mayor or his attorneys or any representatives from his office make any effort to contact the court.
All right,
I don't accuse the mayor
time,
of
then,
being misleading on purpose.
Excuse me,
We all make
Judge
mistakes.
Walker, just for the record, it is very clear that you made a decision based on the one-sided argument that the mayor had prohibited in-person attendance at the church, and the mayor did not. He strongly suggested such a thing, and you would have known that if you had heard from them. It doesn't matter to me that they tried to contact you. Obviously, you didn't let them know that you were about to decide on this case. It was totally ex parte. That is how important all the facts in a case are to you. Thank you.
Thank you. Senator Kennedy.
Thank you, Mr. Chairman. Well, Judge, you've become quite the grounding wire. Politics is unforgiving. I suspect you have figured that out by now. You've been called a revolutionary in the pejorative sense. You've been called McConnell's boy. You've been called McConnell's intern. I think you've been accused of everything except hating golden retrievers. And the subtext of all of this is that you're not qualified. So that's what I want to talk about. Where'd you go to high school?
St. Xavier High School, Louisville, Kentucky.
What was your GPA?
It was 4.0.
What does that mean? Did you make it all A's?
I did, Senator.
You never made a B in high school?
I'm confessing here to the true nerd that I was, who didn't have very many dates, but I did make a goal going into high school of never getting anything less than an A, and that's what I did.
You didn't even make a B in phys ed?
If there were a topic that I was going to get a B in, it probably would have been that.
Okay. I believe you went to Duke, is that right?
I did.
Is it hard to get into Duke?
It is.
What was your GPA at Duke?
It was 3.9.
You made a B.
I made a couple, Senator.
You graduated, did you graduate with honors?
I did. I graduated summa cum laude from Duke.
What does that mean?
There are various levels of honors that you can graduate, and summa is the highest level.
Okay. And then next you went to Harvard Law School, is that right?
That's right.
Is Harvard Law School hard to get into?
It is, Senator.
Now, while you were at Harvard, I read that you're on the Harvard Law Review.
I was.
Do they let everybody at Harvard Law School join the Harvard Law Review?
They don't, Senator.
What percentage of your class was on the Law Review?
I believe there were about 500 people in the class, and the Law Review probably had, I think, about 10% of that, but please don't quote me on the exact number.
Were you an officer on the Law Review?
I was a notes editor.
Did you graduate with honors from Harvard Law School?
I did, Senator. I graduated magna cum laude.
What does magna cum laude mean?
It means I didn't do as well at Harvard as I did at Duke, but it's the second highest honors.
Okay. And then you clerked for Judge Kavanaugh.
That's correct.
Are clerkships for the Federal Court of Appeal competitive?
They're very competitive, Senator.
Hard to get, are they?
Yes.
I've read that Judge Kavanaugh, now of course Justice Kavanaugh, is a highly sought clerkship. Is that right?
That is correct, Senator.
After that, what did you do?
I clerked for Justice Kennedy on the Supreme Court.
Is it hard to get a Supreme Court clerkship?
It's very hard, Senator Kennedy.
How hard?
Well, each justice gets 4 clerks, and at the time there were 3 retired justices, so that made for 39 clerks, 1 for each retired justice, 4 for each active. So there were only 39 clerkship spots available in the country.
After that, you practiced law for a while, did you?
I did. I was an attorney at a global firm, and then a solo practitioner, and then a partner of counsel at a regional firm.
What global firm did you practice at?
Gibson, Dunn, and Crutcher.
They hire a lot of dummies at Gibson Dunn, do they?
They do not.
Okay. Why do you think in light of all those credentials, that the ABA originally found you unqualified?
At the time, the ABA reported that they thought I had the temperament and integrity to be a judge, but that they preferred judges that have had more years of experience after law school than I had.
How many people were on your grading committee with the ABA?
I guess I think there's 1 or 2 from each federal circuit.
How many of them went to Harvard Law School?
I don't know that, Senator.
How many of them graduated with honors from Harvard Law School?
And again, I don't know that, Senator.
How many of them were on the Harvard Law Review?
I don't know, Senator.
How many of them clerked for a United States Supreme Court Justice?
I don't know that either.
Okay. Now, the ABA's had an epiphany, I understand, and you're now well qualified.
That's correct, Senator.
Not just qualified, you're well qualified.
That's correct. It's their highest rating.
Okay. Let me ask you one other question. If you're asked to rule on the Affordable Care Act, you going to follow the law?
Absolutely, Senator Kennedy. NFIB is a binding precedent, and I would absolutely follow it fully and faithfully.
Will you have an open mind about it?
I have an open mind for every argument, every litigant that comes before me.
Thank you, Judge.
Thank you. Senator Booker.
Thank you very much, Chairman. I want to echo comments on both sides of the aisle and just thank you for your being willing to have a hearing, frankly, this kind of accommodating the different levels of engagement and having a hybrid hearing. Thank you very much. It is actually very good to see a lot of my colleagues face to face. This has been a long and difficult stretch for America, and particularly for the state of New Jersey. And if you'll indulge me in making a statement. I'm not sure if I'll have time left for a question, and I appreciate the nominee coming before us under these circumstances. But Mr. Chairman, I've listened to comments on both sides of the aisle, and it's frustrating to me that we are having folks think that many of the Democrats have been criticizing coming back to work. First of all, that's an offense to senators on both sides of the aisle, because I've talked to senators on both sides of the aisle. All of us have been at work in our states, working on this crisis, around the clock, doing everything we can to save lives, to help us to get through this crisis. The issues we've brought up have had nothing to do with us not wanting to come back here to do urgent and important legislating. In fact, I've been working with colleagues on both sides of the aisle just doing that. Senator Grassley and I introduced yesterday legislation to help our first responders who tragically die in the line of duty. He and I went to work. In New Jersey, we've had 27 first responders, firefighters, police officers die, and we want to work together. We have been working together to make sure they get the benefits they deserve. This is not about an issue of coming to work. All of us are doing it. It's an issue that in the midst of a global pandemic where tens of thousands of Americans are dying, where in my state, more people have died in about the last month than died in World War I, the Korean War, and Vietnam combined. This is about a time where we need the kind of leadership that calls this country to common cause and common purpose, not partisanship. I watched in my area 9/11, Hurricane Sandy, a Republican mayor who I didn't like rose to that occasion, called that city and that region to common cause. I watched a governor, Chris Christie, during Hurricane Sandy, not play into partisanship, but call my state together in common cause. This isn't about partisanship, this is about leadership. And at a time that there's real fear in this country, health concerns, real fear in this country for our loved ones and our spouses, real fear about the economy and our economic recovery, as people who've not only seen folks lose their lives, but their entire livelihoods, their life dreams, we have our first hearing here, not about the bipartisan accord, or even debating things that there is some disagreement on, but we're having a hearing for a judge for a vacancy that's not even up until September. This is the moment where we together in a bipartisan fashion could be calling this country, talking to them about what our work really is to do. I can't communicate how deeply just disappointed I am that we're sitting here with a judge that we know would strike division and divisiveness at a time we need unity and common focus and common cause. This is a moment to rally around our nation, to lead this planet out of this darkness, and we have a role in the Judiciary Committee doing just that. And it goes deeper than that because, God, I'm coming from an inner city. Got in a car and drove down here. In this Judiciary Committee, we've worked in a bipartisan fashion to address the racial disparities in this country that have been devastating lives. Chairman and I have stood together and worked on things in the last bill that I'm so proud of doing. But this virus is revealing in ways that are so sobering to the heart the fragility of our society, from issues of domestic violence to Americans living with disabilities, to our seniors in nursing homes, to the Navajo Nation right now that after New York and New Jersey has the third biggest impact. 118 days until a vacancy is open that we're talking about here. And in those 118 days, thousands of Americans will die. And are we talking about that? Are we summoned back here to come together? The first thing we do is a nomination here in this committee talking about a judge that's divisive. No matter what side of the aisle, you know this is partisan divisiveness. I see data now that should give us all pause. It should make us, frankly, many of us weep who love this country. the way COVID-19 has disproportionately harmed communities of color. Preliminary data indicating that this infection is killing Black Americans at staggeringly higher rates. 13% of our nation's population is Black, but according to the data, Blacks account for about a third of the nation's infections, more being infected in the African American community in this country than in many nations around the planet. And what does it say that we're here discussing Judge Walker? The bigger picture is this. There are so many issues we could be discussing. The health and safety of people working in correctional facilities, correctional officers who haven't been able to get the PPE that they need, prisons that have become hotbeds for this pandemic. That's our jurisdiction. We're not talking about hate crimes against Asian Americans, which are going up at astonishing rates right now. We aren't talking about our immigration policy. I've talked to ICE officials and their safety. I could go through chapter and verse the crises that we should be addressing that literally could determine lives lost or lives saved. I am frustrated and maybe a little emotional coming from New Jersey. I look forward to the chance to submit questions for the record. I have a lot of concerns that I expressed, it seems like yesterday when you were just being up for a district court position. I know of your background, Mr. Kennedy. I did not graduate magna cum laude. I just graduated thank you laude. I'm out of here. He got into Harvard or Duke because of his grades. I got in because of a 4.02, but it was 4.0 yards per carry, sir. I was a pretty good football player in my day. But Mr. Chairman, I appeal to you. I want to get to work. This is not it. I appeal to you. We have urgent causes that could bond us together as a committee to deal with the crisis of death and injustice, fragility and pain going on in our country. This makes a mockery of that, sir, and I call to you. There's so much bipartisan work here. We could show this country there's no red or blue states, there's no left or right. There's only one way out of this crisis, is by us bonding together and doing the things that the American people look up to, because I've had a difficult time explaining to people in New Jersey why I was leaving my state in crisis to come back here and do what? Have a judiciary hearing on a person that's not up for 4 months. Thank you, Mr. Chairman.
Well, thank you, and to the people in New Jersey, you've been really hard hit, and I think the governor's done a good job, and you're a very eloquent spokesperson for the people of New Jersey, Senator Booker, and our thoughts and prayers are with your state, who've been hit very hard, and we will do many things you talked about in the coming days. Senator Blackburn.
Thank you, Mr. Chairman, and I'm coming on video. And Judge Walker, thank you for your current service. Thank you for your desire to ensure time.
We're having a bit of a hard time hearing. Can we bring up the volume?
Let's see. Volume is good on my end.
That's better. That's better.
So wonderful. But Mr. Walker, thank you. Thank you for your dedication. I appreciate that and appreciate you for coming to us today. Mr. Chairman, I just have to say in response to a couple of my colleagues that when we talk about why we're here and why we're doing our job and why we're holding this committee today, it's important to realize the U.S. Senate can do two things at one time. We're all deeply concerned about the COVID pandemic, and we grieve every life that has been lost and individuals that have seen their livelihoods lost and those that have lost their jobs, and definitely dealing with that is important. It's important for us to come back to work. And just as my home state of Tennessee is going back to work and going back to regular order, and pushing to get that day where they're returning to normalcy, it is important that we do the same thing, that we take the proper precautions, that we find a way to move forward, that we encourage those that are working on antivirals and vaccines, and that we celebrate that in a free nation, we have the ability to lead the way in solving this problem. But at the same time, it is imperative that we protect the U.S. Constitution, that we fulfill our constitutional duty, that we bring forward these nominees, and that we hear from nominees, and that we complete a portion of the Senate's required portfolio, which is being in the personnel business, making certain that the judiciary is going to be a functioning body, and that should be an important part of what we are seeking to do. So I thank you, Mr. Chairman, for holding the hearing today, and I encourage my colleagues to continue to think we have more than one responsibility that we have to fill. I found it interesting, Judge Walker, that you were asked if you were a part of the conservative revolution, and that being a conservative was couched in a tone of a negative thing. So what I would say, important to turn around and ask the question, is it only socialism that is acceptable? Is it only a liberal viewpoint that is acceptable? Or is it appropriate to be a constitutional conservative? And of course it's appropriate to uphold the Constitution, and we thank you that that is a priority for you. I do want to ask you a couple of things. FISA reform is something that we are going to take up very soon, and it was in 2018 you wrote an article for the George Washington Law Review warning of the risk of giving the FBI too much power. And you pointed out several examples where the FBI infringed on constitutional rights. So I want you to take this last minute and talk about how you balance the two priorities: protecting the American public and safeguarding individual civil liberties as a judge.
Certainly, Senator. In the 2018 article, which I wrote as an academic before I became a judge, I described some unfortunate chapters of our country's history where the FBI in the 1940s and 50s and 60s was not adequately supervised by the Attorney General or by the President. And I suggested that some of the civil liberties that were violated during that era, particularly the civil liberties of racial minorities and political minorities, were violated in part because the FBI was not accountable enough to the Attorney General and to the President, who is himself or herself accountable to the public. And I think political accountability is an important part of our constitutional structure. After all, we are a nation that fought a revolution and declared its independence, in part because we wanted to make sure that the government was accountable to the people.
Thank you, Mr. Chairman. I yield back.
Thank you, Senator Blackburn. I believe that's all we have for you, Judge Walker. Thank you. Congratulations on your appointment. I think you've acquitted yourself well here today. The committee will keep the record open until 5 p.m. on May 13th for senators to submit questions for the record. To my colleagues, thank you for participating. To the staff who set up the room, well done. To all those in the building or trying to keep us safe, we appreciate it. And all those in the fight against coronavirus, you're very much in our thoughts and prayers, and without you, the the country couldn't operate. So with that, the hearing will be adjourned, and thank you very much.
Thank you, Chairman Graham.